Good day, Crime Talk aficionados, and Happy New Year. We have a great docket for you. First, was there an encounter between Bryan Kohberger and one of the surviving roommates? High-profile criminal cases that we're going to be watching in 2026. Another example of how Child Protective Services failed the child. The search continues for a missing 4-year-old boy. A New Jersey man is charged with impersonating a federal officer. Wait until you hear about this story. A story about murder following bail release. Are you shocked? A little pro-legal advice. What not to do right before sentencing. I don't know, like don't threaten the judge. A reality TV personality is arrested in South Carolina following a traffic stop. We have a couple of quick bites of stories that, well, didn't quite make the big headlines. We've got This Day in Legal History. Our quote of the day has to do with day drinking. And our award for 2026 First Dumb Criminal goes to...
All right, lawyer.
Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications. And yes, you can check us out on any of your favorite podcasting apps. Now, before we get started, let me also remind you, it is the first of the year. People are going to be making changes in their life. You need to check people out who are in your life or maybe that are going to be coming into your life. Don't commit dating malpractice. Go to crimetalksearch.com, sign up for a background subscription service. Do that background search on somebody that may be coming into your life. Find out everything about them. Phone numbers, email addresses, social media presence. Do they have a criminal history? Are they married? Are they divorced? Do they have to put themselves on one of those public registries? You know the ones I'm talking about. Go to crimetalksearch.com, find out today. And remember, you can cancel at any time, and the report is literally prepared while you wait, and it is emailed to you, and you can even ask for updates for new information when it becomes available. Also, let me remind you to go down, to hit the link down there. That's right. Hit the link for all of the Crime Talk merch. There's some new stuff there. Listen, you didn't get what you wanted for Christmas because you all wanted Crime Talk merch. You didn't get it. Use your Christmas money that Santa gave you and get some merch today. All right, let's go ahead and open the record for the first time in 2026, January 2. First on the docket, was there an encounter between Bryan Kohberger and one of the surviving roommates? Well, some recent disclosures from investigative documents in the University of Idaho quadruple homicide case indicate that Bryan Kohberger may have been in the same retail store as one of the surviving roommates just days before the November 13th, 2022 killings. So for those who don't recall or don't know, Bryan Kohberger pled guilty back in July of 2025 for the murders of 4 University of Idaho students and is now serving 4 consecutive life sentences without the possibility of parole. And he's currently at the maximum security institution there in Idaho. So according to this supplemental report, records show that an individual identified as BF, believed to be referring to the surviving roommate, Bethany Funk, made a purchase at a Target store on November 10th at approximately 4:09 p.m. Kohberger, then a criminology graduate student at Washington State University in nearby Pullman, Washington, completed a transaction about 90 minutes later, about 5:42. Now, the report explicitly notes that it remains unknown whether Funk and Kohberger overlapped in the store or even interacted. The location of the target is not specified in any available details. And though Kohberger resided roughly 15 minutes from the victim's off-campus resident house there in Idaho, now Funk and fellow roommate Dylan Mortensen were present in the home during the early morning attack, but they were unharmed. Now, Kohberger entered, obviously, a guilty plea by some surprise to some people right before his trial, avoiding the possibility of a death sentence. Now, in the months since his incarceration, obviously, Kohberger has lodged several various complaints about prison conditions, including concerns about his meal portions and the quality of the fruit provided on his meal tray. So the question is, was this just coincidence? Maybe complete random happenstance that they both went to the same store in the same small general community, or was there something nefarious there? Listen, I've told you before, having practiced criminal defense for 30 years, I don't believe in coincidence when it comes to criminal cases, right? Now, the proximity in the time and location between Kohberger and one of those roommates raises obviously questions about, maybe possible premeditation or prior awareness. And even if there is no direct encounter is ever confirmed, I'm sure at some point they asked Miss Funk and there's been no indication that she recalls any interaction. But like I said, I don't believe in coincidences. Let's face it, Kohberger, he's an awkward individual. There was something weird going on, obviously, why he went to that house there in Moscow and killed those 4 college students. And I'm just going to throw it out there. It was probably some weird sexual thing that he had, or maybe he just did it just because, for the thrill of it, perhaps. I don't know for sure. But the reality of it is there's no evidence to suggest that he just randomly picked this particular house to do those killings. Now, we may never know since Kohberger is not talking, but do you believe he was stalking someone in that house? I do. Who do you think it was and why? Next, a couple of high-profile criminal cases that we're obviously going to be following here at Crime Talk in 2026. So there's obviously several cases that we're going to be talking about in 2026. And first, we're going to be watching the Luigi Mangione case. Now, Mangione faces multiple charges across both New York State, Pennsylvania State, and in federal jurisdiction as well for the fatal shooting of the healthcare executive back in 2024. He has pled not guilty. Pretrial hearings obviously still ongoing with a federal hearing set for January 9th. And obviously a lot of anticipated evidentiary rulings coming up in May. No full trial dates have been set thus far, though proceedings are expected to extend into late 2026 and beyond. Like I said, you got the state court case in New York, you got the federal court case in New York, and let's not forget about the case in Pennsylvania as well. We got to Tyler Robinson. Obviously, he is charged with aggravated murder related to the sniper-style shooting of a conservative activist, Charlie Kirk, back in 2025 at a university event there in Utah. He's entered a plea of not guilty. A preliminary hearing is scheduled for May 18th of 2026, and no other earlier proceedings are thus far scheduled. No trial date has been established yet either. Let's not forget about Rex Heuermann. That's right, the Gilgo Beach accused murderer. Heuermann awaits trial on 7 murder counts linked to remains found in Long Island, New York. Obviously, the charges are consolidated into a single proceeding over the objection of the defense, I might add. And the next pretrial hearing is January 13th. Trial is anticipated in late 2026 at its earliest, but we'll be following that as well. Nick Reiner obviously faces 2 counts of first-degree murder for the stabbing deaths of his parents, prominent Hollywood figures, and his spouse in 2025. An arraignment is scheduled for January 7th. Obviously, there's potential defenses may involve mental health considerations, including the reports of schizophrenia and possible insanity pleas. No trial date has yet been set, and obviously that'll take place there in California. Let's not forget about Sean Mickey Steins, right? The former Letcher County Sheriff is charged with first-degree murder in the shooting of a district court judge in 2024, and he's pled not guilty and intends to pursue an insanity defense. Pretrial motions, including venue changes, are ongoing. No trial date has been established because there's some psychological evaluations taking place in regards to the not guilty by reason of insanity plea. Corey Richins, remember? Yeah, she is accused of aggravated murder by poisoning her husband with fentanyl in 2022. Jury selection begins February 10th, with trial proceedings commencing on February 23rd and expected to conclude by late March. How about Lindsay Shriver? That's right, Miss Shriver faces charges related to an alleged murder for hire plot against her former husband. Trial scheduled to begin in March of this year. That's actually going to take place in Nassau, Bahamas. Then we got the Sarah Grace Patrick case. Miss Patrick is charged as an adult with murder and aggravated assault in the shooting deaths of her mother and stepfather. Has a trial commencing January 5th of 2026, and that is in Carroll County, Georgia. How about Larry Millette, charged with the murder and the presumed death of his wife who disappeared in 2021. Trial is scheduled to begin on March 9th in Chula Vista or San Diego County there as well. How about Lindsay Clancy? Clancy faces murder charges for the strangulation of her 3 young children in 2023. Obviously, the defense centers on mental health issues, including postpartum psychosis. Trial scheduled to begin in July of 2026. How about Shauna Gardner, accused of involvement in the murder for hire plot resulting in the death of her former husband? Trial is scheduled to begin on August 3rd of 2026. Hey, let's not forget about Alec Murdaugh. Although he was convicted of murdering his wife and son, well, that appeal is pending, and oral arguments will be held before the South Carolina Supreme Court on February 11th. And if he wins, there's the possibility of a new trial. Normally, there is a very short turnaround from the time that the mandate issues on any sort of reversal to when a trial must be commenced, usually within 180 days. And who could forget the John Benet Ramsey case? Although still unsolved from 1996 and no charges have been filed, there's been some updates indicating that there's some new evidence collection, retesting of items, and maybe some ongoing interviews. And with advanced DNA analysis, who knows what to expect maybe by March of this year. Now, let's face it, the Boulder Police Department and the Boulder DA's office have kind of fumbled this case since 1996. So I'm not holding my breath on that one at all. But if that were come to fruition and there'll actually be a case, guess what? It'll be the biggest case in, this century, I guess. Next on the docket, another example of how Child Protective Services failed a young child. Police have charged Richard Baptiste and his girlfriend, Annika Woods, with first-degree murder and multiple counts of child abuse in connection with the death of Baptiste's 10-year-old daughter, Rebecca, who succumbed to severe injuries back in July of 2025. Now, Rebecca was discovered unresponsive on July 27th of 2025 near a remote off-grid campsite in rural Apache County, Arizona, where the family had relocated from Phoenix earlier that month. The living conditions involved a yurt without electricity or running water, with family members sleeping on thin mattresses and transporting water from a distant store. Medical examinations revealed extensive injuries, including brain hemorrhages, burns, missing toenails and hair, and widespread bruising and cuts consistent with prolonged abuse. Prosecutors have alleged both physical and sexual mistreatment extending to Rebecca's younger siblings. Well, newly disclosed police documents from late last year indicate that Rebecca, then age 9, sought assistance at a Phoenix gas station after fleeing her home. She reported to officers that Woods had struck her with objects and imposed rigorous physical punishment. Visible injuries such as bruising and a bloody lip led to her evaluation at a Phoenix Children's Hospital. However, the investigation concluded without charges after the adults attributed the marks to self-harm, citing inconsistent accounts and absence of independent witnesses. Well, records further document multiple prior concerns raised by the Arizona Department of Child Safety, including reports from Rebecca's school, Empower College Prep, spanning several years. The Child Services has acknowledged involvement with the family dating back a decade, but stated that many allegations did not meet the threshold for further action or removal from the home. In the immediate aftermath of Rebecca's discovery, emergency response records noted delays in medical intervention and limited emotional response from the caregivers. That's the parents. Baptiste later admitted to certain disciplinary actions, but denied responsibility for the fatal injuries. Now, Rebecca's community remembered her fondly as an intelligent and compassionate young child. Empower College Prep honored her with a memorial event, a pink flowered tree planted in her memory, and a commemorative plaque. Now, the case prompted an internal Child Services review identifying systemic challenges in case management, along broader calls for state officials, including the governor, for a comprehensive examination of child protective protocols to prevent similar outcomes. They failed, ladies and gentlemen. That's the way it is. Now, over the years, I've handled several cases involving child abuse resulting in death. And I would say over probably 90% of those incidents, there were prior calls or involvement with Child Protective Services. And basically, Child Protective Services was too busy. They didn't think it met the threshold. because, let's face it, being a bad parent isn't a crime. Should be in lots of cases, but it's not. But the reality of it is it's not a crime. And so as long as, when people know child services shows up, they clean the house up, clean up the rat poop in the corner, and they put some food in the refrigerator, they're going to meet the threshold of being an okay parent unless the kid has physical abuse there. And normally when there's those signs, so to speak, well, it usually results in something bad happening in the future. And then eventually somebody does a review and they find out, the Child Protective Services didn't do their job and the people were lazy or they didn't have enough money or resources. And it's the same thing. And they get up and they do press conferences and they say, we're going to hold people accountable, which they never do. And then, they're going to implement reforms, which maybe they do for a little bit. And then it all goes away. And then the same thing starts happening in a couple of years. It's that way, I don't know, at least where I've practiced. And you can see these patterns everywhere else as well. Now, I get it. You want to raise your child in peace? I get that. You don't want the government to tell you how to raise your kids? I totally get that. But you can't beat them. You can't abuse them. Physically, sexually, anything along those lines. And sometimes, if there's thought of it, it probably involves just a little closer investigation to see what is really going on. Next, a search continues for a missing 4-year-old boy. Police in Walker County, Alabama, resumed a large-scale search on Friday morning for a 4-year-old boy who has been missing since Wednesday. Jonathan Everett Boley was last seen around 11:30 a.m. in the 7,000 block of Highway 195, a rural wooded area near Jasper. Now, according to the Walker County Sheriff, Nick Smith, the child's 6-year-old brother reported that Jonathan and the family's black Labrador retriever crossed under a fence line into the woods and did not return. The boys, who reside primarily with their mother in Florida, were visiting their father during a scheduled holiday visitation period under a custody arrangement that allows limited annual time with the boy and the father. Law enforcement responded promptly to the report, deploying aerial support, drones, canine units, and ground teams involving volunteers in multiple agencies, including the FBI. Despite extensive efforts covering hundreds of acres, no evidence of the child has been located in the surrounding woods, as confirmed by apparently even thermal imaging and other search technologies. In a separate development, though, during the initial investigation, police discovered explosive materials on the father's property while securing their residence. Jameson Kyle Boley, a former military member, was subsequently arrested and charged with unlawful manufacturing of a destructive device. Sheriff Smith stated that the explosive charges are completely unrelated to the child's disappearance at the time, though neighbors had reported hearing detonations from the area in recent weeks. The home search was temporarily halted for safety reasons until, bomb experts could come and clean up the site. Jonathan is described as approximately 4 feet tall, weighing about 50 pounds, blonde hair, blue eyes. He was last seen wearing a yellow Mickey Mouse shirt, black pants, and a Paw Patrol pair of shoes. The black Labrador accompanying him also remains unaccounted for. The child's mother traveled from Florida upon learning of the situation and is cooperating with the police. Family members have expressed hope for his safe return, describing him as an active child who enjoys outdoor activities. And obviously, police are asking for anyone with any information, including footage from any doorbell or trail cameras, to contact the Walker County Sheriff's Office. Obviously, everybody's hoping for the safe return of the young boy. The fact that the dad got arrested, he obviously let them allow the police to search the house. Probably should remember yourself before you do that. Do I need to remove any explosives that probably I shouldn't have, or probably require some sort of federal licensing? Now, I'm not saying dad's involved. Frankly, there's no evidence that dad's involved in any way in regards to the disappearance of the young child. Maybe watching him as best as he should have, perhaps, but we'll deal with that at a later date. Anyway, now the dad's going to be in custody and not out searching for his kid. You think maybe the police would have, seized the stuff, and then when this was all resolved, then arrest him? That's the way kind of it normally works. Anyway, next on the docket, a New Jersey man is arrested for impersonating law enforcement. Wait until you hear this story. A 32-year-old man from Sewell, New Jersey, has been charged with impersonating a law enforcement officer after police allege he used his wife's marked U.S. Department of Homeland Security vehicle to respond to a police call that he initiated. According to the Washington Township Police Department, the incident occurred on December 10th of 2025, shortly after 2 p.m., when officers were dispatched to a home under construction following a report of an open front door. The caller, later identified as Nicholas Cabral, arrived at the scene simultaneously in a marked Homeland Security vehicle with emergency lights on. Cabral, dressed in civilian clothing but displaying a gold badge, reportedly identified himself as a Department of Homeland Security officer and attempted to assist the police in securing their residence while armed with a handgun. Now, although he held a valid New Jersey permit to carry a firearm, the investigation confirmed that Cabral is not employed by the Department of Homeland Security or any other law enforcement agency. Further inquiry revealed that the car belonged to Cabral's wife, who is in fact a legitimate Homeland Security police officer who was out of state on an official assignment at the time. Data from the automated license plate reader indicate that the vehicle had been operated with emergency lights on multiple occasions during her absence during a visit to a fast food restaurant. Now, needless to say, the Department of Homeland Security came and picked up their car, and a warrant was issued for Cabral, who surrendered to police on December 11th. His firearm was also confiscated, and he was released pending a court date. Cabral faces charges of impersonating a law enforcement officer and possession of a weapon for an unlawful purpose, and he's scheduled to appear in court on January 22nd. Now, obviously, it's serious business impersonating a police officer. Obviously, there's risks to the public and the officers as well. But I think where the real tricky thing would be was when Mr. Cabral had to tell his wife that while she was gone, he was out driving around in the police car with the lights on, picking up fast food. And then he wants to be a police officer. I think the chances of him ever being a police officer are now slim to none. And makes you wonder if maybe there won't be some divorce filings in his future as well. Next, another case where the system failed the victim. That's right, a murder following a bail release. Shocking, isn't it? So in December of last year, just a couple days ago, Multnomah County District Court judge in Oregon sentenced Mohammed Osman Adan to life in prison with the possibility of parole after 25 years. Now, Adan pled guilty to second-degree murder back in August of 22 for killing of his domestic partner, Rachel Angel Abraham, who was the mother of several children, including 2 fathered by Mr. Adan. Now, the court records and statements from the Multnomah County District Attorney's Office detail a pattern of escalating abuse throughout 2022. Now, back in May, Abraham reported that Adan punched her in the head while intoxicated. In June, despite a restraining order, Adan entered their shared apartment, strangled her multiple times, threatened her life with statements such as, "I'm going to put you to sleep," prevented her from seeking help by breaking her cell phone. Visible injuries included a black eye and a swollen cheek, and they were noted by responding police officers. At Adan's arraignment following the June incident, Abraham addressed the court directly, expressing fear for her safety and that of her children. She highlighted research indicating that strangulation in domestic violence cases is a significant predictor of homicide, stating her desire not to become a victim. Adan was initially released with GPS monitoring and other conditions, but he subsequently removed the device and guess what? Returned to the residence. And then in August of 2022, following another reported assault, Adan was rearrested. Over prosecution's objections, bail was set at $20,000. And the Portland Freedom Fund, a now defunct nonprofit organization aimed at assisting low-income defendants, particularly those from communities of color, posted the required 10% or the paltry $2,000 to secure his release on August 20th. Shortly thereafter, Adan again removed his GPS monitor and returned to the apartment where, guess what, he inflicted severe knife wounds to Abraham's face and body before strangling her to death. 3 young children were present in the home during the attack. The medical examiner confirmed strangulation as a cause of death, and that was occurring after the stabbing. Now, the senior deputy district attorney, Melissa Marrero, described the case as an absolute tragedy that never should have happened, emphasizing that clear warning signs were present and that Abraham had taken all available steps to protect herself, including that's right, obtaining a restraining order and contacting the police. Prosecutors argued that Adon should have remained in custody, criticizing the decision that led to his release. The district attorney expressed outrage at the bail payment, calling it reckless action with severe consequences. And the Portland Freedom Fund, in a statement issued shortly after the murder in 2022, noted that Adon had been deemed eligible for release by the court, and he was referred to community support as a provider for young children and showed no indications of concern during post-release contact. What, do you think he's going to tell the people that are helping him get out of custody that he's going to go over and kill the mother of his children? Anyway, the case has renewed scrutiny of pretrial release practices in domestic violence cases. Now, was it a soft on crime policy responsible for this woman's death? Prosecutors have attributed Abraham's death, at least in part, to decisions perceived as lenient, including the judicial setting of bail despite opposition and the intervention of a third-party bail fund. They contend that these actions disregarded established lethality risk factors in domestic violence cases, allowing a dangerous individual to be released. However, the matter is not solely attributable to broad soft on crime policies, right? The court determined that Adon was eligible for bail, standard judicial discretion in many jurisdictions, and bail funds, including the Portland Freedom Fund, operate within the existing cash bail system, which critics argue disproportionately affects low-income defendants. Or they could just do what we do here in Colorado and just give everybody a personal recognizance bond, although that's kind of going away for stuff like this. Anyway, supporters of bail reform advocate for risk-based assessments over financial requirements, aiming to detain high-risk individuals. So these kind of cases are always difficult, ladies and gentlemen. Now, I can tell you, as a criminal defense attorney, when there was bail reform, it made the defense attorney look like a rock star to his clients because they were getting out of custody. Now, as a member of the community, you would want to be saying, no, judge, don't let this person out. Your job as an attorney is to argue for the result that your client wants, which is to get out of jail. And in DV cases, they're tough. They're tough, ladies and gentlemen. Sometimes they're ridiculous. I had a client once that was arrested for flinging the checkbook across the table to his wife when they were arguing about money. And he said, fine, then you handle the finances. The police came because a neighbor heard some arguing, and he was arrested for that. Needless to say, the case got ultimately dismissed, and things went fine. As far as I know, no further disputes. But yes, when it does involve, strangulation, punching, that's not a little argument over money. That's something a little more severe. And choking is personal. And most states now have strangulation, domestic violence charges that can be filed. It's second-degree assault here called strangulation. Basically, when people start choking you and you start seeing stars, that's not a good sign. And yes, it usually does mean that it's probably going to result in future violence. Not good. Had a case, murder, strangulation, years ago. Guess what? Prior arrest for, you nailed it, strangulation. Goes back, reconciles with wife, removes GPS, strangles her. And strangulation, ladies and gentlemen, is very personal because you just don't die from strangulation just because somebody starts seeing stars. It takes several minutes, potentially 2 to 5 minutes, to actually strangle somebody to death. So that is very personal. That is the epitome of after deliberation. And you're staring the person right in their face when they're passing out and all that kind of stuff. Bad news. So yeah, there's allegations of strangulation. You need to take it seriously. Courts, prosecutors, victims, and defendants need to keep their hands to themselves. Said it before and say it again. Never, ever, ever hit or strangle a woman. Don't mess with kids. You don't mess with women. It's that simple, ladies and gentlemen. Next on the docket, a Cincinnati man faces new charges after allegedly threatening the judge just prior to sentencing. Yes, pro pointer here, ladies and gentlemen. Let's not threaten the judge that's going to sentence you. So a Cincinnati resident's actions immediately prior to a court sentencing hearing have led to serious additional criminal charges, highlighting the severe consequences of threatening, that's right, a judge, a judicial officer. Please meet Xavier Jackson. He's now facing proceedings for a probation violation stemming from a 2024 methamphetamine possession case and has been charged with retaliation and aggravated menacing. Now, police allege that on December 30th, just before entering the courtroom, Jackson made explicit threats against Judge Christopher McDowell. According to the police reports, Jackson stated that he would kill the judge and his entire family if prison was imposed. Despite the alleged threat, guess what? Judge McDowell proceeded with the hearing and sentenced Mr. Jackson to 1 year in prison for the probation violation. Now, the new charge of retaliation and aggravated menacing carry a potential for significant additional incarceration if Mr. Jackson is ultimately convicted. Now, obviously, he's entitled to that presumption of innocence. And I'm sure he will probably be saying the judge should have recused himself, but probably not, because if that were the case, then people would do it all the time if they don't like that particular judge. Anyway, this guy was almost a dumb criminal, but no, we got a better one for you than this guy. Anyway, Jackson is scheduled to appear in court again on January 3rd for proceedings related to his new charges. Just a reminder, appropriate conduct when you go to court. Threatening a judge, not appropriate conduct, ladies and gentlemen. Threatening anybody in court, not appropriate conduct, particularly from a defendant. That goes for the victim's side of the family as well. Court, be dignified, right? Next in the docket, a reality TV personality is arrested in South Carolina. Grace Lilly, the 27-year-old cast member from the reality television series Southern Hospitality, was arrested late at night after a routine traffic stop in Mount Pleasant, South Carolina. The stop occurred about 11:20 p.m. near a Circle K convenience store when officers observed a vehicle making an improper lane change. A traffic camera system had previously flagged the vehicle due to information suggesting it might contain a person with an outstanding warrant, prompting the police to make the stop. During the subsequent search of the car, police located a small container labeled, quote, "Happy Pills," end quote. That was on the cap. Inside were approximately 12 white tablets marked with a P imprint on one side, along with the half of an oblong blue tablet lacking any visible markings. When questioned by officers, Lilly stated that the blue tablet fragments was Xanax prescribed to her for a medical use, and that the white tablets were her birth control medication. However, she was unable to provide documentation supporting the prescription or identifying the specific brand of the contraceptive pills. No original pharmaceutical packaging was found in the car either. Miss Lilly was taken into custody following that little discovery, and details regarding specific charges have not been fully disclosed as of this time. It is under investigation. Another pro pointer here for you, ladies and gentlemen. If you have a prescription and you're going to be driving in a car or you're going to be traveling, you need to keep your drugs in the prescription bottles. Otherwise, how do they know, the police, if they make contact with you, or that drug dog sniffing people when you come through customs, how do they know that you're not smuggling drugs versus you have a prescription for those controlled substances? Pro pointer. Keep the prescription bottle with you. It's actually a crime. It's a misdemeanor. I believe it's a petty offense in the state that I practice for not having your drugs in the prescription bottle or having the prescription with you. Just something to think about next time you go through customs. Don't say I didn't warn you. All right, a couple stories that didn't quite make the big headlines. A Bakersfield man charged with the first-degree murder of his wife, shooting death. Another domestic incident, police say in Bakersfield, California, have charged a local resident with the fatal shooting of his spouse amid allegations of infidelity. The event occurred on December 30th at a residence in Tallulah Falls Court in Northeast Bakersfield. The suspect, Manuel Leal Robles, and his victim, Anna Karen Robles, were married and shared a home in the area. And according to the investigation report, Robles allegedly used an AR-15 to shoot his wife in front of at least one of their children. He later confessed to officers, repeatedly stating, quote, "I killed her," end quote, and citing his wife's supposed unfaithfulness as the motive. Witnesses include the victim's children, identified him as the shooter. Robles had a prior history of domestic issues, including an incident 2 weeks earlier where he damaged his wife's vehicle over similar accusations. He was arrested at a nearby shopping center and faces charges of first-degree murder, willful cruelty to a child, and a corporal injury to a spouse. He remains in custody. Next, police in Massachusetts have taken a man into custody following a deadly altercation that escalated into a prolonged police standoff. This all occurred on December 27th at the home in Massachusetts. The suspect, James Marsh, who is 64, and his unnamed wife were involved in a heated argument that turned violent, resulting in Marsh allegedly shooting her. The victim was pronounced dead at the scene from the gunshot wound, and after the shooting, Marsh barricaded himself inside the residence, pointing the firearm at police officers, which prolonged the standoff for over 4 hours before he surrendered. Now, Marsh, the resident, now faces multiple charges, including murder, assault with a dangerous weapon, and unlawful possession of a firearm. He appeared in court on December 29th, where details of the incident were outlined. Obviously, once again, domestic violence, the holidays. I don't know what to tell you, ladies and gentlemen. What can you do? Next, a woman faces murder charges in her husband's Christmas Day killing. A holiday turned horrific in Northern California when a woman was apprehended for shooting death of her partner. The incident took place on December 25th, Christmas Day, at the home there in Oroville, California. The suspect, only identified as Julie, and her husband were at their residence when a shooting was reported. Deputies from the Butte County Sheriff's Office arrived and found the victim dead of a gunshot wound. Thorough search of the property uncovered firearms and evidence linking Julie, to the shooting. She was arrested on site and charged with 1 count of murder. They don't know the motive just as of yet, but once again, domestic disputes during stressful periods like the holidays. And yes, a TikTok influencer was arrested for the fatal hit and run that she was streaming. That's right. So in a little bit of a twist involving social media and a vehicular homicide, a content creator has been detained for a deadly accident. The event happened nearly 2 months prior to the arrest on Christmas Eve of last year, 2025, for a TikTok influencer known as Tea Time. Anyway, she was apprehended in connection with running over a pedestrian while live streaming. The victim, an unnamed pedestrian, died from injuries sustained in the hit and run. And during the investigation, police discovered a freezer at Tea Time's residence, adding a kind of a macabre element to the case, though its direct relevance is a little unclear. Anyway, she faces charges related to the reckless driving and leaving the scene, with prosecutors emphasizing the dangers of distracted driving via social media. Tea Time is in custody at this particular time. Tea Time. What can you do? Don't live stream the crime scene. That's what you don't do. Don't do it. Next on the docket, this day in legal history, January 2nd, 1788. The great state of Georgia became the 4th state to ratify the Constitution, an early milestone on the path to reaching the 9-state threshold needed to put the new federal framework into effect. January 2nd, 1906, the United States Supreme Court applied full faith and credit principles to require recognition of a sister state's garnishment judgment, illustrating how interstate enforcement of judgments shaped the law as we know it today, right? If you get a judgment in state A and the person moves to state B, should you be able to collect your judgment under the full faith and credit clause of the United States Constitution? Yes, you can. You can't just keep jumping around states to avoid judgments. Next, January 2nd, 1923, the case of Blandberg Brothers versus United States. What does that have to do with? Well, the court addressed federal admiralty litigation involving the seized vessel and related jurisdictional issues. It was kind of an example of how wartime era seizures and maritime procedures produced lasting doctrine in the United States courts. Now, what does that have to do with much of anything? Well, what do I keep saying, ladies and gentlemen? Most things in the law have already been decided before. It just depends on the facts. The law is pretty much settled as to most things. And it all happens before. Everybody acts like it's why did this jump out at me? Well, it was because they're talking about seasons of vessels today. There's a procedure for that. They do it all the time. They really do. Anyway, in that particular case, the court addressed the federal admiralty litigation involving seized vessels and the jurisdictional issues. It happens all the time, ladies and gentlemen. Next, January 2nd, 1951, the Johnson Act restricts interstate transportation of gambling devices. Yes, ladies and gentlemen, back in 1951, Congress thought that there was such a problem of the interstate movement of gambling devices, right? Slot machines, that they passed legislation. To strengthen the ability of a state and federal government to regulate commercial gambling. Guess what, ladies and gentlemen? It's a slippery slope. You allow people to use slot machines. Next thing you know, they want to use the lottery. Next thing you know, they're gambling away the rent and grocery money. Got to stop that slippery slope, at least in 1951. And now you can't do anything without being told what the odds are of a particular sporting event at any given time. This day, January 2nd, 1975, the Federal Rules of Evidence. That's right. Why is that significant? Congress enacted the Federal Rules of Evidence, creating a uniform nationwide evidence code for federal courts and reshapes trial practice in both civil and criminal litigation. Prior to that, people just kind of made stuff up. Congress passes Federal Rules of Evidence. Obviously, the court gets to, just engage in that rulemaking process. And now most states' rules of evidence and practice and procedures mirror the federal rules as well. How about our quote of the day? Now, there's a little bit of an inside story here. We've been trying to locate somebody, all right? We'll just leave it at that. Been trying to locate somebody. We've been doing what we could to find somebody. And let's just say we found them. And we found them, and coincidentally, I guess, gambling, like we were just talking about, at a slot machine. And it was early in the morning. Now, maybe he didn't go to bed. Maybe he still thinks it's like 11 p.m. at night. I don't know. But it was funny because the video I got to see of it, well, it had this particular individual drinking a couple of beers at 9-something in the morning. So what does this have to do with a legal quote of the day? Well, woe unto them that rise up early in the morning, that they may follow strong drink, that continue until night, till wine inflame them. Now, this comes from Isaiah 5:11. Now, I'm not the most religious guy in the world, not really at all, but this verse has historically been referenced in temperance movements, right? The no drinking movements, and legal debates on alcohol regulation to highlight concerns about, early day drinking as a sign of excess or possible dependency, which is what I've been saying about this guy that we've been trying to serve. And yet, here we are confirming it. What can you do? Like I said, while not a direct quotation from a judicial opinion or statute, it underscores societal and ethical views on, morning alcohol consumption that have influenced the legal framework regarding being intoxicated. I can tell you, judges frown upon that, particularly in DUI cases, vehicular homicide cases. You got a problem. Okay. Anyway, next on the docket. And our award for 2026, first dumb criminal goes to a Eureka, California man. Ladies and gentlemen of Crime Talk, gather round, because a new year has barely begun, and we've already crowned our inaugural contender for the dumb criminal of the day. It took less than 24 hours into 2026 for one individual to set the bar so astonishingly low, and we're here to celebrate his spectacular failure in criminal ingenuity. Meet Byron David Donahue, whose New Year's resolution apparently involved kicking off 2026 with a bang, straight into county jail. Now, according to official booking records, Mr. Donahue was arrested by the Eureka Police Department at approximately 12:16 a.m. on January 1, mere minutes after the ball dropped and champagne corks popped nationwide. Now, while most of us were toasting to fresh starts, Donahue allegedly embraced the opposite, a swift return to custody. Now, details of his alleged offense remain scant in public reports, but the timing alone is poetic justice. One can only imagine the officer's New Year's greetings. Happy 2026. You're under arrest. And in a year that's just getting started, Donahue has wasted no time securing his nomination. Is this the pinnacle of poor planning? Attempting mischief before the confetti has even settled? We think yes. Honorable mention goes to the other early entrants booked that night at the Humboldt County Jail. But Mr. Donahue edged them out for sheer audacity and timing. That's right. What do you think? Does Byron David Donahue deserve the top spot, or will someone dethrone him before the month is out? Drop your votes and the predictions in the comments. We've got 364 days left of contenders, but this one is going to be a head start. Look at this video. All right, ladies and gentlemen, that's all we have for you today. Thanks for taking the time to watch the show. We appreciate you. We'll see you next time. And remember, the Constitution matters.